Hi, I'm Greg Dell with attorney Alexander Palamara. We're going to talk about Reliance Standard disability appeals and some tips on how to win these appeals. And also, Alex, we're going to share about our experience in handling so many of these and providing people with things that will help them to avoid a denial, and if they are denied, how to get back on claim. So when you deal with Reliance Standard and someone first calls you about them and says, I've been denied, I mean, you deal with 35 different disability companies. What are the first things that come to your mind in dealing with Reliance?
The first thing that comes to my mind in dealing with Reliance, it's a kind of funny question because unfortunately I only see when they deny claims most of the time, so I see a lot of the bad things that they do, so it kind of frustrates me. And even when I'm handling a case and doing an appeal, I've seen them do terrible jobs on appeals as well. I've seen them ignore appeals altogether, which is actually fine for me because we end up winning that lawsuit pretty easily. But I've seen them do some bad work. And I know there's good people over there. I have great contacts over at Reliance Standard. There are really good trained people, but some of the people that are assigned to the appeal sometimes are not as trained as they should be, or maybe they're overwhelmed. Maybe they have too many cases. For whatever reason, I've seen them do some bad things. So when I think about Reliance Standard, sometimes I get frustrated when I think about them. That being said, I love taking on Reliance Standard claims. I know their policies pretty darn well. I know their denial letters. I know the format for the denial letters. It's not like they reinvent the wheel each time they deny a claim. They use the same format. So if someone's been denied disability insurance claims, just what I want to do is I want to review that denial letter. So send me a copy of that denial letter. I'll gladly review it and give you my assessment of your claim and the probability of winning your appeal or probability of potentially winning your lawsuit.
So with Reliance Standard, they're probably one of the mid-pack size companies. They're not the biggest, they're not the smallest, but they've been around for a while. Like you said, it tends to be more of a standard form denial letter where they're filling in the blanks. They kind of have a regimen as to how they review their denials, although they have a little bit of turnover over there with their employees, so they don't get a level of consistency in how they're reviewed. But Reliance Standard, required by law, gives you the denial letter to the claimant, and then they also give you the right to get the claim file. Talk about in when you're doing these appeals, why it's so important for you to really tear up this claim file and figure out what's going on in there, and then the most important aspect of what you need to prove in order to get a Reliance Standard denial reversed.
So the claim file is so important. So the denial letter will tell you why they're denying the claim and what justification they believe that they have to deny your claim. And they have to point to any piece of supportive documentation that they're relying upon to deny your claim. Oftentimes, when someone applies for benefits or is on claim, they'll send your files out for review by an independent physician consultant. And they'll use this consultant's report as justification to deny your claim because the consultant will say, hey, listen, I see this, this, and this. There's no way this person has these restrictions, limitations. They're no longer disabled, or they're not disabled. So the claim file is important because everything that the insurance company that Reliance Standard has relied upon to deny your claim is inside the claim file. I need to go through that claim file. I need to find that information. I need to find that consultant's report. I need to find, let's say they send you to an independent medical examination. I need to find that report from the IME. Maybe they did internal reviews by nurses or in-house doctors. I need to find those reports because if my client really is disabled, those files, those reviews that they're relying upon have to be wrong. There has to be something that's wrong with them. It's either the doctor just interpreted information wrong, the doctor's overlooking or blatantly ignoring information that was submitted in support of my client's claim, or whatever reason. There has to be something wrong with these reports, and I got to find those reports, find what the holes are in those reports so I can fill up those holes with argument and with proof that proves my client's claim. That's what I do in appeal. I get the claim file, find those reports, get updated records from my treating providers, my client's treating providers, get updated testing done, whatever I can do to show objectively as possible my client has these issues. And I take those updated reports, updated testing, and I've plugged the holes of those reviews so I can prove to the insurance company that not only is their claim wrong, their claim decision wrong, but that my client is disabled and deserves to be put back on claim.
So a lot of times what I tell the claimants is, look, when we go ahead and do your appeal, we have to make you look horrific on paper, because is all the insurance company is going to know is what they see on paper. They're not going to come out and see you. They're likely not going to examine you. They're not going to have their in-house doctors call you. They may have their doctors call your doctors, but we really got to get everything in submitted, and that comes from building additional evidence, which we also call proof. So we first have to see, when we go through the claim file, like you were saying, like what did they think was missing, or what did they say was weak? And based upon that information there, if they really did miss something, then that makes it a little easier because we can say, hey, look, you just didn't see this, here it is. More often than not, they did see it, they just chose to interpret it differently. So the question is, how can we enhance that? How can we amplify it? How can we make it have a bigger magnitude so that the next time when they review the appeal, which is going to be a whole new person, which is what the law requires, that that person is going to basically get to the point where they cannot reasonably disagree with the evidence that we're submitting. And that's the real art on the medical. And you know, you talk about tools of what additional testing do I want to need or get, and what types of testing do you sometimes use and experts you work with on your appeals to prove that the person's disabled?
Well, if it's a physical claim, I love to send my clients to functional capacity evaluations. Well, they'll meet with a physical therapist who will put them through physical functional testing to see whether they have the ability to do sitting, standing, walking, lifting, carrying, any physical requirements of any occupation. So we're going to prove my client can't do their job or can't do any gainful occupation, which is typically a sedentary job. We're going to prove it, or send them to this testing to see if it proves it for them or for us. Additional, let's say they have cognitive issues. We can send them to a neuropsychological evaluation, which is a full-blown, hours-long testing to show whether you have cognitive dysfunction. There's also a little lesser one that we're using a lot now called the cognitive functional assessment, which is a little shorter of a test, but also shows whether my client has cognitive issues. Like a lot of people nowadays have long-haul COVID claims. And a part of the long-haul COVID claims, I guess there's some physical issues, but a lot of it is cognitive issues and memory issues and issues with thinking, So we use the CFA, the Cognitive Functional Assessment or Neuropsych evaluation to prove these issues, or again, the FC, the Functional Capacity Evaluation. Additionally, there could be other objective tests to objectively prove whatever diagnosis or whatever symptoms you have to objectively prove that you have a certain condition. Because maybe when someone filed a claim, they only had symptoms and they didn't have a diagnosis yet. And the insurance company says, hey, anyone could be complaining of this, but there's no proof of it, no objective evidence. So maybe we send them out to get the objective proof of these diagnoses.
Right, like so maybe they go for an MRI, maybe they go for x-rays, maybe they go for a nerve conduction study test, maybe they have a CT scan, all types of diagnostic objective evidence testing that they really just didn't need. Number one, it's expensive to get that. And number two, the doctor was like, let's treat the symptoms, not necessarily the chart, because at the end of the day, it's all about your symptoms, not necessarily what we see on the chart. But for a disability company, it's all about the chart, and they don't care much about the symptoms. Right. So it's complete reverse of how a doctor treats a patient. So that makes it challenging, but there could be other good objective evidence. And many times, people go out for objective evidence testing, like MRIs, X-rays, and things like that, and it doesn't show something significant enough, but they could still be in debilitating pain, and it doesn't mean it doesn't exist. No doctor is going to say, looking at this MRI or looking at this X-ray, this person should not be in pain, or this person should be in pain, because it's not a measure of pain based upon that objective evidence. So it helps if there is some objective evidence improving the claim, but it's not the end-all, be-all, and that's one of the challenges here in these appeals. We talked about medical, but then there's also vocational elements to a claim because of the definition of disability. What types of definitions of disability and how's occupation usually defined in a Reliance Standard policy?
So Reliance Standard, like most disability insurance companies, have a change in definition of disability after a certain period of time of benefits being paid. Typically for the first 2 years, you qualify for benefits if you convince the insurance company that you are unable to perform the material duties of your own occupation. If you prove that, then you get benefits. After 2 years, it becomes a little bit more difficult to qualify. You have to prove that you're unable to perform the duties of any gainful occupation, which opens up the potential jobs that they say that you can do to basically being unlimited. They have to take into account your training, education, and experience. It kind of brings it back in, but typically they say any occupation is a sedentary job. If you can do a sedentary job that pays you a certain amount of money, they're going to say that you're no longer disabled. Regarding own occupation, they look at the national economy. So maybe your job as an accountant requires you to lift a box that's 100 pounds. Most jobs, being an accountant does not require that. Or let's say your job as whatever. Just because your specific employer has specific requirements of your job, they're going to ignore all that. They're going to see how it's done in the national economy. So how it's, if you're a truck driver, if you're, whatever you are, how the typical job, how the typical person has to perform that job is how they're going to look at your occupation. Again, for any occupation, almost always they consider it to be a sedentary job. So if you can do a sedentary job that would pay you 60% of your prior monthly earnings, then you're no longer disabled. That's what the insurance company loves to do. And my favorite's when someone worked for like in the oil industry, because they make a lot of money and they had a heavy duty job, but now the insurance company has to prove they can do a sedentary job that pays $120,000 a year. Someone with that training, education, experience, not a lot of jobs open up for the sedentary jobs. I feel they always have a hard time with those type of claims, but we'll do our best to prove to the insurance company that you can't do your job or any job. We'll send you to any testing we can possibly do, but it can be difficult because it's not how your job is performed at your occupation, at your specific employer, which some of my clients have a hard time grasping, like, wait, but my job required me to do this. How is this? That's not fair. And it's like, I understand that, but it is what it is.
So we often try to work with a vocational expert, or we'll
100%.
go out and use what other people in the industry and try to say that the way in which you, our client, explain how the job was performed, if we can get other experts or other people in the industry to say, yeah, absolutely, that's how it's performed, and it's different than the manner in which the way the insurance company wrote up the occupation, then we're going to do everything we can to prove that, and that can become very helpful because they do tend to push things into these classifications of sedentary, light duty, medium, which is really just nonsense, because that would mean like you and I could sit here all day in this chair for 6 hours, and if that's all we had to do for our jobs, then we would be fine. But there's so much more than just sitting at a desk or whatever it may be, and that's the lowest level of work, is just a sedentary job. They tend to ignore the cognitive aspects of these things. So you get your vocational, you get your medical, you have all your evidence and you put it in, but you don't write an appeal telling the insurance company all the things they did wrong. And why is that?
Well, I also have to convince them, what the medical records and documentation says. I have to prove that my client's disabled. I'm going to say you guys were wrong here and here and here, and here's what the evidence actually shows, and here's why my client can't do the requirements of their job or the requirements of any occupation. So I don't have to say, you guys got it wrong here, here's what it proves, and this is how you have to prove your case. The only way you can prove your case is with that proof that we keep on talking about. So any appeal is twofold: proving the insurance company that my client's disabled and proving they did a terrible job in denying the case.
And I know when we do these appeals, we don't tell them everything that they should do, because we're always thinking about also what happens if we lose this, what's the judge going to look at? And if that standard of review is that the judge has to find that they acted unreasonably, we are not going to provide Reliance Standard with the roadmap to how to act reasonably, because if we wrote an appeal and said, you need to do these things and you didn't, then they may just go ahead and do that and still find that you're not disabled, then you're screwed. So you have to artfully, in the way in which you write these, write in such a manner that you go, here's all the evidence, and we're very, very fact specific. We're not giving them case law saying you're dead wrong about this, this, and that, even though we know about hundreds of cases that show that they're wrong, and we're not going to tell them everything they did wrong. We're going to give them all the evidence, and we're going to make it so that their doctors have to agree, but also leave the door open so that if they want to continue to act unreasonably, that we know we can win or have the best chance of winning at the next level. And that's something that's hard to do, and you got to have a lot of experience to write in that manner.
It is weird because sometimes you want to keep arguments in your back pocket for potential lawsuit, and you have to, it's a cost-benefit analysis of what you put out there and what you hold back, because if they screw this up on the appeal, you're going to win your lawsuit that easy. They're that much easier. So it is an art to doing these appeals.
So Alex, what we like to do for claimants is to go ahead and get us a copy of the denial letter. We'd love to have the policy as well. We'll immediately do a review of the information you send us. We'll get on the phone with you, spend as much time as you need to let you know what we think are the chances of winning your claim and what's going to be involved. And we always provide this free initial consultation no matter where you live in the country.